Okay, Mary.
And do you have a slide set, Rob? And can he screen share, Gretchen?
Yes.
Okay. Well, Rob, welcome so much. This is a subject that I think can get overwhelming at times for people that have never gotten into the weeds with the EPA or the Supreme Court. So I think my goal is to have a better kind of big picture understanding of, first of all, how it initially was treated under the Clean Water Act and why it went to the Supreme Court, and how the court's decision changed the way these laws about wetland management are being now delivered. So, and you can tell from my language, to me, it's hard to put this in simple words, but I'm going to count on you to help us do that. So again, thanks so much for joining us.
Thank you for having me. It is a pleasure to be here. Can you see my screen now that I'm sharing it?
It's very clear. Thank you.
Okay. Well, good afternoon and welcome everyone. As stated, my name is Rob Lee and I'm a staff attorney at Midwest Environmental Advocates. We're a nonprofit law center based in Madison, Wisconsin, that combines the power of law with communities facing environmental injustice to secure the rights of all to healthy water, land, and air. I certainly want to thank the League for asking me to present today on the ever-evolving definition of waters of the United States under the Clean Water Act and how that applies to wetlands regulated under Section 404 of that act. MEA has long focused on Clean Water Act implementation, including the regulation of discharging fill into wetlands. And I have been had the privilege of furthering that mission and working on those things as a staff attorney for the last 5 years here. So I'm excited to be able to impart some of that knowledge to you this afternoon. I will flag, right, we only have so much time together. And as Mary was saying, this is kind of a dense topic here that I could probably just talk about for hours on end, but I gather that you're not interested in that. So I'll try to convey as much information as possible. I'm recognizing we're not going to be able to run every potential issue to ground, but these are complex. So some of my slides are a little text heavy, and I will apologize for that, but I'll do my best to walk you through that. I want to give you a quick overview of what I'll be discussing. First, just want to give you some quick background on Section 404 of the Clean Water Act and the specific language at issue that's being interpreted by the courts there, discuss the source of authority for the Clean Water Act, and then a couple of early cases that help define jurisdiction over wetlands in particular. We'll talk about the big 2007 fractured decision from the US Supreme Court in Rapanos v. United States that had a lot of implications in the Sackett decision that came out earlier this year. I'll talk about then this sort of odyssey between the Obama era Clean Water Rule, the Trump administration's Navigable Water Protection Rule, what Biden tried to do right after that, right? And then, of course, the decision from earlier this year in Sackett v. EPA. And then I'll touch on the revised rulemaking that the EPA and the Corps came out with implementing that Sackett decision. So that's what's on the docket for today, and I will just trudge along here. So as I'm sure many of you know, the Clean Water Act was enacted in 1972, and there's all sorts of provisions in there. Had a couple of major programs, though, that were designed to help protect water quality. The first major one in Section 402 is the National Pollutant Discharge Elimination System, which is really the discharge of pollutants from point sources. So, for example, like a pipe coming out of the back of a factory discharging, wastewater with some contaminants in there into a river. That's not what we're talking about today. We're talking about the second kind of major program under the Clean Water Act, which is Section 404. and that regulates the discharge, not necessarily of just pollutants, but specifically dredged or fill material into navigable waters. And I guess the best way to describe the difference between the two, right? When you're talking about discharging wastewater and pollutants, you're typically talking about something that can be like washed very far downstream, all of those things. And while that can happen with like fill material, we are really talking about a comparatively solid substance that's going to stay put in a waterway, right? Or a water of the United States here. And certainly that's what, that is the provision, right? That allows both the EPA and the US Army Corps of Engineers to regulate discharges into wetlands. And I do want to be clear here that while the EPA sets water quality standards and does have a role in the permitting process, it is the US Army Corps of Engineers that issues permits in the under Section 404, not EPA. So EPA is involved in that process, but it is the Army Corps there that leads the administration of that section. So, and the second thing I want to point out here is the whole Clean Water Act is sort of riddled with this concept of cooperative federalism, where the federal government can establish a broad framework that the states, if they want, can implement. And while almost every state, I think it's 47 states now, have been delegated the authority to administer that 402 program, that other pollutant discharge program, only 3 have been delegated the authority under Section 404 away from the U.S. Army Corps. That includes, as you'll see on the screen there, Michigan, New Jersey, and Florida, who's a recent addition to that there. And so while there are jurisdictions who have been delegated authority under there, there's many other jurisdictions who have their own independent wetland regulatory mechanisms, right? That are in addition to the federal regulations. So you may need 2 permits. But further still, there's another category of states who have no wetland regulations of their own and rely entirely on the federal framework there to protect the wetlands in their state. So certainly, as we alter the jurisdiction of the federal government, that can have very large consequences on the ground, depending on where you're at and in which state and what they may have in place to back it up. So as you'll see here, that under 404A, it is an exception to the general prohibition on the discharge to navigable waters in the Clean Water Act. And it says you can discharge dredge or fill material into, and I have this underlined here, navigable waters, if you get a permit from US Army Corps. That phrase, navigable waters, is defined in the Clean Water Act, even though it had a very large pre-existing had been defined in pre-existing case law pretty extensively there. So this is a little bit different than that, but it's explicitly defined to mean waters of the United States, including territorial seas. Unfortunately, the phrase waters of the United States itself is not defined in the Clean Water Act. So that is the big issue, is what does waters of the United States mean? And how far does that extend? I do want to touch very quickly, though, because the limits, right, of what may be included in that definition are very much a jurisdictional issue that is really related to the authority of the federal government to engage in this type of regulation. Kind of back to civics class, right? Our Constitution is one of limited government, our federal Constitution anyway, right? And Congress and the agencies who get their powers therefrom are only supposed to exercise the powers enumerated, right, in the Constitution. So there is no like general provision allowing, right, the regulation of the environment. But what we do have is the interstate commerce clause, and certainly water quality and the ability to navigate waters at the founding and really up to today is very much a commercial issue. But that is also the limitation, right? They can only regulate those waters that have some sort of plausible impact on interstate commerce, right? And the stream of commerce going in there. So that you'll see all the inquiries, if you read the cases, they kind of start at this bare minimum there. But that is a limitation here. It's not like in Wisconsin, for example, where we have a very scientific definition of wetland, which affords jurisdiction in the first instance. Sure, to regulate it, you got to be a wetland and a scientific wetland, but that's a necessary yet insufficient, right, condition. You also has to have some impact on interstate commerce. So, but as I said, there was this sort of traditional or accepted historical definition of navigable waters, and you'll see it here. I even have a quote from a case all the way back from 1871, so you can see how long the courts have been dealing with this issue. But traditional navigable waters, which I think everyone concedes constitute waters of the United States, are those that are navigable in fact, or readily susceptible of being navigable in fact, right? And you can see this more in-depth definition here in the Daniel Ball case of 1871. But I want you to think about not just those traditional navigable waters like the big rivers that you can float, a canoe or a large boat for commercial reasons down, but other types of waters that fall short of a traditional navigable waters. Those are all the way in, right? But what else are? The reason, though, we need to know, and I'm not just focusing on wetlands here, is ultimately to determine whether or not you have a wetland that can be regulated under the Clean Water Act. It's got to be an adjacent wetland, and it has to be adjacent to another body of water that is also a waters of the United States. So to determine whether you have an adjacent wetland, you need to know whether the body of water it's next to is either a traditional navigable water or a tributary to that traditional navigable water. What about ephemeral streams? That's kind of been an issue that's been debated back and forth in the regulations. Think about adjacent wetlands, but one of the questions in the cases is what does adjacent mean exactly? Is it just it's near a surface body of water? Does it have to be abutting it? What does adjacent mean, right? That really has been the heart of some of these questions answered in Rapanos and Sackett. What does adjacency mean? Another issue, interstate wetlands. Okay, we have a wetland, but it goes between two states. And then another issue that's been addressed in a water feature, isolated, non-navigable intrastate waters and wetlands. Okay. Pushing through here, just wanted to flag two early cases here that I think informed Rapanos and Sackett, of course. Riverside Bayview, an early on case in 1985, holding, right, that if it actually abuts a navigable water, if the wetland actually abuts it, then it is a WOTUS, right? So right next to that water. And some interesting lines of thought out of those cases that were carried forward and quoted in Sackett, right, that I'm raising here. The difficulty in figuring out exactly where the surface water ends and the wetland begins sometimes, or where is that line of demarcation? And also recognizing the ecological connection between wetlands and surface water, particularly when they're abutted, but as we'll find, right, in many instances, simply being right next to it or not being next to it doesn't have anything to do with whether there is an ecological connection at all. but may have something to do whether there's jurisdiction for the federal government to do anything about it. So we know from Riverside Bayview that wetlands that actually abut a navigable waterway is a WOTUS. And so very generally speaking, at least some adjacent wetlands, right, will qualify here. Now we have what, just for short purposes, I'll call SWANK here in 2001. And this was a case over the Corps and EPA's migratory bird rule, basically saying that that there are ecological benefits even for these isolated waters that don't really have any connection to any at all traditional navigable waters, even though there was still this sort of very broad ecological argument there. And ultimately, the Supreme Court said that they can't extend it quite that far, and that Clean Water Act jurisdiction does not apply to isolated intrastate waters, whether or not those are wetland or maybe like a creek or something like that. It does distinguish Riverside Bayview and points to it. This is the first time we see this phrase in SWANK, significant nexus, right? To kind of describe that ecological connection mentioned in Riverside Bayview. And that will be the phrase used later on that becomes the topic of much debate. So again, I'm just going to keep trudging here. So that, I said 2007, but it looks like it's 2006, the Rapanos case that came out there, building off of those two prior cases and really focusing the attention to when a wetland may be considered adjacent to an otherwise waters of the United States. And how they framed the question, even in the text of that case, was going back, they don't say ecological connection or even frame it as significant nexus, but they say, can it be adjacent to just because of a hydrologic connection, even if, like in Riverside Bayview, it's not abutting that otherwise WOTUS. So here's really where it got even more confusing, I think, for everyone, because unfortunately, no rationale in Rapanos was able to command a majority of the US Supreme Court. What we had was a fractured court with no majority. We had a dissenting opinion joined by 3 justices. We had the plurality opinion that was, quote unquote, the opinion of the court authored by Justice Scalia, and it got 3 other justices to join, so 4 there. But we also had a concurrence by Justice Kennedy. He agreed with the outcome of Justice Scalia's decision, but did not agree with the rationale getting there on how to answer this question up here. So Justice Scalia's decision is what really, for the first time, articulates and establishes what we now know as the continuous surface connection test. And this gets back to that problem in Riverside Bayview of trying to draw that line of demarcation. But here we see, from a plurality of court, only those wetlands with a continuous surface connection, which may be another way of saying abutting, right? Like it's literally right next to it. So you can't see the difference between where the water ends and the wetland begins, right? Those are the ones that are covered by the Clean Water Act. But wetlands that only have an intermittent or physically remote hydrologic connection to other waters of this of the state, waters of the United States, do not implicate that boundary drawing problem. And that the lack of a necessary connection to cover waters and they even use that same language that we would call a significant nexus, right? So this is, again, fashioned as the opinion of the court, but it did not command a majority, and it was really just the conclusion that there was no jurisdiction over the 4 different wetlands at issue in that case. It was a combined case, that there was no jurisdiction. Justice Kennedy also would not have found jurisdiction in that case, which is why he concurred in the judgment. But he did not agree with this continuous surface connection test, and would answer, right, or would find in more instances, right, that there is Clean Water Act jurisdiction when there is a significant nexus, even if it's not directly abutting, right? And it very well may be that a mere hydrologic connection is enough, right? If you're going to fill wetlands, that while there may not be a surface connection, is an underground connection to there, and there's a recharge, and there would have implications for water quality, then there should be jurisdiction there. He talks about the chemical, physical, and biological integrity of those waters. If there would be an impact or a potential impact, then there's jurisdiction. So that was Justice Kennedy's concurrence, but it's, no justice joined that. It was just Kennedy kind of out here on his own in this middle position and agreeing with the result, but not the rationale. The dissenters, which I don't have in my slideshow here, they would have simply deferred to the expertise of the Corps and the EPA as to what constitutes waters of the United States. That is based on a whole lot of case law that we do not have time to get into today, and ultimately isn't going to impact the ultimate decision. So, oops, I'm going too fast here. How do I go back? So we have these competing tests, right? We have a difficult situation. Okay, which of these does EPA or the Corps implement? Well, ultimately what it did was, at first, in between 2006 and 2015, it basically said if it meets either the significant nexus test or the continuous surface connection test, which is another way of saying if it meets the significant nexus test, because that's much broader, right? And you likely would have jurisdiction over anything that there would be jurisdiction under the continuous surface connection test. But how does that work, right? How do we have a decision authored and sponsored by one Supreme Court justice kind of overcoming the decision of the fractured court, right? A 4-4 on the other side. It's actually based on another obscure Supreme Court precedent, when there is no majority holding, that finds that the controlling opinion is the one that would have garnered a majority of votes if all the justices were forced to choose. And the idea is that the 4 dissenters, if they had to choose between the significant nexus test or the continuous surface connection test, they would have chosen the significant nexus test. And so therefore, that is what appellate courts, right below the Supreme Court, including right where I'm sitting here in the 7th Circuit, that it is the controlling opinion, the significant nexus test. So that's what, about 9 years after Rapanos, we had the Obama administration attempt unsuccessfully to put forth a rule implementing significant nexus and all the implications therefrom in interpreting waters of the United States. They were immediately sued. You can see here we had the attorneys general from 27 states sue the Obama administration within 2 days. And within 4 months of that 2015 rule being finalized, a court had put it on hold. And it remained on hold for a significant amount of time thereafter. And ultimately, no resolution in that case, when there was then a change, of course, in administration. After the 2016 election, as we all know, President Trump took over, and the Trump administration issued its intent to review and revise, right, the Clean Water Rule in 2017. So right after coming into office there, and in doing so also delaying the implementation of the Obama era rule for an additional 2 years before ultimately repealing and replacing that with the 2020 Navigable Waters Protection Rule. I say here that Navigable Waters Protection Rule implements the continuous surface connection test light, because it's certainly not the full test as will be seen and implemented in the Sackett decision. There are certain instances in that 2020 rule where waters that weren't immediately adjacent or abutting another waters of the state were still considered jurisdictional waters, right? Even if it's separated by an artificial structure, things like a road or a berm or a ditch or things like that. Some of those things were still jurisdictional even under the Trump administration's 2020 rule. But much like the Obama administration was sued very soon after that came out, over the next 3 months, all sorts of enviro orgs and states and even ranchers mounted suit against the Trump administration. And ultimately in 2021, we even had that rule vacated by an Arizona federal district court. So, and then we had another presidential election. Of course, Trump lost and Biden came back in and basically came out with a decision for the EPA to revert back to that sort of to that gray area between Rapanos and the 2015 rule, to just go back to the interpretations that were implemented then, while the Biden administration was reviewing the Trump rule, which it was allowing to stay in effect at that time. But by the time, and so ultimately, right, the Biden administration, they did do that, right? And pass a rule that purported to go back to those. But by the time that Sackett decision was released earlier this year, even the Biden administration rule was similarly enjoined in 27 states at that time, and not being applied there. So that gets us all the way up to Sackett, where, of course, there's all sorts of jurisdictional issues, but folks were looking at this and some other ones, but principally this one as sort of one of the perfect kind of test cases to get back at this question that they tried to answer in Rapanos, weren't able to garner a majority, to bring it back before the court and try to provide some clarity, especially with all this whiplash effect in between each administration. We can't change jurisdiction every 4 years. We need to hopefully get it settled. So unlike the other cases I've provided, I do have some facts from the decision itself, right? So this is how the majority who in the case, right, characterize the facts in the case. So they're not necessarily my characterization of them. But the property in question comes from Idaho and Bonner County. They purchased it more than 20 years right before getting a decision there, but they almost immediately began to backfilling their property because they intended to include what the court called a modest home. I don't have the specs for the home. I don't know whether it was modest or not, or what the court thinks is modest. But anyway, they bought the property with the idea to build a home, and they started backfilling it. And some of that backfilling included wetlands. And so EPA used its significant nexus test or approach to determine that those wetlands were jurisdictional, that they're adjacent to an unnamed tributary. So not a traditional navigable water, but a tributary to a traditional navigable water, but is on the other side of a road. So the wetlands are actually separated from that tributary by a 30-foot road. That unnamed tributary then fed into a non-navigable creek, which then fed into Priest Lake, which, although is an intrastate water, is nevertheless big enough of a water to be considered traditionally navigable for economic purposes and therefore waters of the United States. But the real issue there is whether or not the wetlands, being 30 foot or on the other side of a 30-foot road, were adjacent to the unnamed tributary, which I believe that the court conceded was itself a waters of the United States because of what I'm assuming is a continuous surface connection between the tributary, the non-navigable creek, then to Priest Lake, right? But in order to establish that significant nexus, they weren't all just considering that tract of wetlands being filled in a vacuum. They considered those wetlands together with other wetlands so similarly situated, right? So there's this big wetland complex near there, the Kalispell Bay Fen. I'm not sure if I'm pronouncing that correctly, but that they considered similarly situated. And so they sort of applied this cumulative impact analysis and saying that, right, if those wetlands, including a part of them, were to go away, there would be a significant effect on the ecology of Priest Lake, and therefore those wetlands are jurisdictional, and the backfilling of those, despite them being separated and on the other side of the road, was unlawful. So again, the question there, what is the proper test for determining whether wetlands are adjacent to a WOTUS, right? And they don't just consider it in the abstract. It has to be an actual case or controversy, and these facts are the case or controversy. So using that as the lens, the court, or the majority of the court, ultimately adopted Scalia's plurality opinion from Rapanos, that is the continuous surface connection test, and specifically articulating that the Clean Water Act only extends to those wetlands that are adjacent to a body of water, that itself constitutes a WOTUS. And here's some important language here. To itself be a WOTUS, right, it has to be a relatively permanent body of water connected to traditional interstate navigable waters, right? Relatively permanent. That's important. It has to be that, right? And it has to have that continuous surface connection with the water, hearkening back to Riverside Bayview, making it difficult to determine where the water ends, the wetlands begins. Where is that line of demarcation? If you can't tell, that may be a very good sign that you have a continuous surface connection. So it was a big case, and it was a big deal. But what they basically are saying is that, no, you can't go back to that pre-2015 interpretations where you're asking both questions, because significant nexus isn't enough to establish jurisdiction. There must be a continuous surface connection. So all of those wetlands that do not have a continuous surface connection, even if they're extremely near and have a demonstrable hydrologic connection, right, and an impact on that surface water, those wetlands, there would be no jurisdiction from the federal government over those. So that's a big problem, because it calls into question the Biden administration rule that was trying to go back to those pre-2015 interpretations. And it meant that large portions of the Biden administration rule did not comply with Sackett. So just a couple of months after the Sackett decision was published, the EPA and the Corps came out with a joint revised rulemaking to bring that rule into compliance with the Sackett decision. And in doing so, it did not go through any public notice or comment period whatsoever. This is just a unilateral decision by them implementing the Sackett decision here. Now, there's even some debate about whether or not they've adequately done that. I haven't seen a lawsuit yet, but certainly folks have questioned the legality of whether or not the Biden administration has gone far enough to comply with Sackett. But right here, you see what they do based on that decision. And throughout the rulemaking, they remove the significant nexus test, not only for wetlands, but for all waters of the United States. So In order to be a waters of the United States, the tributary itself must have a continuous surface connection, or it's not a waters of the United States, at least for purposes of Section 404. It revises adjacency to remove some language defining it with terms such as neighboring, right, which suggest less of directly abutting and more of, in close proximity to type things. They removed all of that language, and it basically just replaces it with has a continuous surface connection with another WOTUS. And then also, they also removed what they had previously included, interstate wetlands, right? They were including interstate wetlands, any wetland that was a WOTUS under the Biden rule, if it traversed the boundary between two states, regardless of whether it had a significant nexus or continuous surface connection. And based on some certain language in the Clean Water Act, and that being really, and the interstate provision being meant to open water, that was also removed there. And so the actual revising rule, which is right here, is only 6 pages long versus the actual rule that it revises, which I think is 100. And then if you take the supporting materials, you're getting into hundreds and thousands of pages. But so the revising rule, right, just 6 pages long, and makes these very minor as far as amount of text that they're cutting out, but really major as far as impact. So you remember the list I had before, right, of the other water features to consider, in addition to just traditional navigable waters, which, as you see here, everybody knows are in, right? Here are these other types of water features, and whether or not they will be considered jurisdictional in light of the Sackett decision, right? I kind of mentioned this, right? But if it's not a traditional navigable water itself, but is a tributary thereto, and there is not just a significant nexus, there must be a continuous surface connection to a traditional navigable water, that tributary's in. Ephemeral streams, however, those are not, as I mentioned in the case, relatively permanent bodies of water. Now, some of them may be, right, there is some gray area here, because there may be water bodies that don't have water in it year long, but don't necessarily only have water in there in response to precipitation, right? And so there may be like a little bit of gray area that needs to be hammered out to figure out what relatively permanent means. But if we're talking about water features that really only have water in them in response to precipitation, those are generally going to be out. When they certainly were in under that 2015 Obama rule, if there was any sort of impact to downstream waters. Adjacent wetlands, again, only in if there is a continuous surface connection to another WOTUS, which can either be a tributary to a traditional navigable water or a traditional navigable water. But we have to have both a wetland and a WOTUS to even be able to determine whether the wetland is adjacent to that WOTUS. And the only way it is, based on Sackett, is if there's a continuous surface connection there. No longer ecological, hydrological connection, whatever you want to call it, does not suffice. Again, interstate wetlands out unless they qualify themselves as an adjacent wetland, right? But that would be a jurisdictional wetland just because of the adjacency and have nothing to do with the interstate circumstances there. And then finally, this is what that Swank case was getting at, and that we've known for some, at least since 2001, that our isolated non-navigable intrastate waters and wetlands are out, right? Those are out based on that case. So certainly Gretchen is going to talk about potential implications at the state level, right, and what this could mean or play out in different states. And I will say it matters, and it will be state specific, the impact based on all sorts of things. I'll also point out that even with this, I think there's still some gray area, and whether or not, as applied in certain situations, there is a continuous surface connection. So while we may, at least for the time being, be settled on an overall test and framework, which insofar as it provides clarity, I suppose is a good thing, right? I don't like the deregulatory aspect of it, right? But there's still some gray area, and some of this will still be subject to future litigation here. But what I've seen is that by removing, right, going away from the significant nexus test, right, and going to the continuous surface connection, there has been a significant reduction in the amount of jurisdiction that the federal government has as a backstop over wetlands. And that is particularly pronounced based on initial estimates in the upper Midwest region. As many as 80% or more of wetlands that may have had jurisdiction over previously may no longer, the federal government may no longer have jurisdiction over, right? And if there's nothing at the state level in its place, well, that can lead to very large water quality problems, right? But also deprive us of all of the other wonderful ecosystem services that wetlands provide. Flood control, right? And they do provide habitat for migratory birds, other species, endangered and threatened species, things like that. That water quality function that I talked about before, right? And just really crucial that we maintain what we have, because we've lost so much already, right? And here in Wisconsin, like approximately, I want to say half of the wetlands that we historically had. So anyway, that's the end of my presentation. I hope that was at least clear to some extent and didn't confuse you further. I will say that I'm happy to have anybody reach out to me. Here's my contact information. I'll also say that MEA has an environmental intake hotline. So if you have an environmental issue, including with wetlands, and you want to call and ask us a question, we may be able to answer it, or may be able to put you in touch with the folks who can. And then finally, you'll see at the end of my email address there, our website, midwestadvocates.org, all sorts of great information on all sorts of issues, and even an opportunity to sign up for our mailing list, which if you do, you will get this really great newsletter that we put out once a month. So do I turn it now over to Gretchen, or should I look at the questions here in the chat first?
Let me go now, Rob. Stop sharing and I'll start.
Okay.
I have a question for you, quickie. What's the territory that you covered? Was it the whole upper Midwest, or anywhere in the country, or just Wisconsin, or?
Oh, that MEA covers?
Yeah.
Yeah, we are right now exclusive to Wisconsin. I think when we were first founded 24 years ago, it was very aspirational. Right, and that we may extend beyond the confines of Wisconsin, but there have been a lot of really cool organizations that are similar to us open up in Minnesota and in Iowa and elsewhere. So not much of a need. But yeah, we focus on Wisconsin, but very much interested in what's going on throughout, right? The kind of Western Great Lakes states, because it has an impact here and downstream.
Yeah. So if anybody in Illinois, say, had a question, they could reach out to you and you can help them find somebody in Illinois to work with them, right?
Yeah, very likely so. We should be able to put them in touch. Same goes with those other states.
Okay, good. Well, I'm going to dig in on my bit here then. And what I'm looking at, I showed my daughter this and she said, my goodness, there's so many acronyms in that. Clean Water Act and UMR states, Upper Mississippi River Region states. And I'm also going to look at the legal whip and voter positions and what's next. So you guys are all seeing my transcript. How wonderful. So like Rob said, Clean Water Act is nationwide. but it's delegated to states. The federal government administers it, the act, but states can pick up the authority to administer the Clean Water Act in lieu of the federal government doing it. So federal law sets out the criteria for delegation, and states and tribes have to demonstrate the capacity for program and effective administration, including enforcement. I used to work for the Minnesota Pollution Control Agency, and we regularly had to prove, we had to report our activities, and we were also subject to challenge, and we were forced to prove ourselves in challenges. Like Rob said, the decision covers discontinuous waters, isolated wetlands and ponds and ephemeral streams. But here in the Midwest, we're mostly looking at wetlands. And wetlands haven't had an easy trajectory since the Europeans showed up here. We've gone from 45 million acres of wetlands before European settlement down to just 18 million now. And looking at our individual states, Illinois started out with 8 million acres of wetlands and has lost 85%. Iowa started out with 4 million, has lost 89%. Minnesota, we had 18 million and a half here, and we're down to 43%. And part of that I'll talk about in a little bit more. Missouri, from almost 5 million, they've lost 87%, and Wisconsin has lost 47%. When we look at states that have broad coverage on their own, so that's what Rob was talking about, right? So states that rely on the feds are the ones you see in green here. The federal government is the sole regulatory authority in Iowa and Missouri in our region. But in Minnesota and Wisconsin, we have strong laws that protect wetlands, and we have for some time. And that's why you see the loss in Minnesota and Wisconsin much lower than in Iowa, Missouri, and Illinois. In Illinois, they have some limited coverage. And so, it's different in different states, and it's going to, the Sackett decision means that the patchwork is going to be a whole lot patchier. And that really matters. So, wetlands in Missouri and Iowa bred the birds that came to Minnesota, so we will see a loss of wildlife as more and more wetlands are degraded and disappear in the north. The League of Women Voters has been around, as you all know, 102 years now. And we have a long history of advocacy on the Clean Water Act. This is from the Impact on Issues, the LWVUS Statement of Positions. The League's citizen activists helped to pass the landmark Clean Water Act in the early 70s and worked to protect and expand and strengthen it through the 90s. And they found that water issues, from groundwater protection to agricultural runoff to the safe drinking water, have energized League leaders, especially locally, for decades. And that's very true. That's why we have this LWV Upper Mississippi group, because we are energized about water. There you go. Looking specifically at the League positions on water, the League supports water resource programs and policies that reflect the interrelationships of water quality, water quantity, groundwater, and surface water, and that address the potential depletion or pollution of water supplies. So that puts us squarely in the discussion here with Sackett and the new Clean Water Act, which we'll talk about in a minute. The League also supports measures to reduce water pollution from direct non-point source discharges and from indirect non-point sources. Again, directly dealing with this, the Clean Water Act. The League supports policies to achieve water quality essential for maintaining species populations and diversity, including measures to protect lakes, estuaries, wetlands, and in-stream flows. And finally, the League supports stringent controls to protect the quality of current and potential drinking water supplies, including protection of watersheds for surface supplies and recharge areas. There is new federal Clean Water Act legislation that's floating around now, if you don't mind the pun there. It has been announced but not introduced, so I'm not exactly quite sure what the status of that means, but it was announced on October 18th. The authors include Rick Larson from Washington, Grace Napolitano from California. They're the ranking members in different committees. and 116 other House Democrats. It's titled the Clean Water Act of 2023, but there's no bill number yet. The press release that they put out in October 18th, the bill would undo the damage of the Supreme Court's misguided Sackett decision by reinstating the historic and bipartisan federal-state partnership that protected our waters for over 50 years. And this changes the definition of navigable waters. Sorry about that. Changes navigable waters to protected waters. And by doing that, they would mean all waters subject to the ebb and flow of the tide, the territorial seas, and all interstate and intrastate waters and their tributaries, including lakes, rivers, streams, both full-time and intermittent and ephemeral streams, wetlands, and all impoundments of the foregoing, to the extent that these are subject to the legislative power of the Congress. And so that would probably still mean to me, maybe Rob can help me out on this, that would still be under the Commerce Clause, but maybe not. And then the term wetland would mean those areas that are inundated or saturated by surface and groundwater at a frequency and duration sufficient to support a prevalence of vegetation adapted for life in saturated soil. So that's kind of where things are now. And we'll switch to questions. Mary Ellen, are you still here? I'll stop sharing. There we go.
Got to get unmuted. Yeah. So I want to just to start out, Rob. So the impact of Sackett, of the court's decision, allowed them to go ahead and complete their backfill and build their home. Is that correct?
Well, we got a little echo there, but yeah, they ruled in favor of the Sacketts.
Did they do that? I'm asking, I mean, did they go ahead and build their house?
Oh, I don't know. That's a really good question. Obviously, it's kind of weird when you read through all of these cases, right? Sometimes you forget that these involve real people on the ground, right? And it can seem sort of in the abstract. I will say that they seem like we're going back and forth, like I say, for almost 20 years. On that, and maybe they were able to figure out something else to build their home or on part of the property that wasn't a wetland. I really don't know, but the decision only came out in June. So,
and what kind of defense did they, as individuals, offer? I mean, they bought the property knowing there were wetlands. I would assume they couldn't plead ignorance, right?
Well, I think
their defense solely on just the definitions in the Clean Water Act and their interpretation.
I think generally speaking, they don't have, like, in ignorance is usually never a defense, right? I think the law presumes, even criminal law, that all of us know what it says, right? I really, it's not clear, I don't think, from the facts in the decision itself. I haven't gone back and read the briefing under that about on any of those questions, right? To know for sure, right? But that was likely their defense, right? They sought, I imagine, a jurisdictional determination. If I recall, I'm trying to think. Sought a jurisdictional determination from the court, maybe in I want to say the late 2010s, and there was a previous iteration of the case that went in front of the Supreme Court about whether or not they could even challenge that jurisdictional question, right? So their challenge or their defense of that, whether or not they knew in the first instance where those were technically wetlands, right, that they needed a permit for, which maybe we give them the benefit of the doubt and say that they just didn't realize, who knows, but their defense was, regardless of whether they're wetlands, the federal government doesn't have any jurisdiction over them, right? Because they're not adjacent to a waters of the United States. Because they're set, they can't be adjacent because they're separated by this 30-foot wide man-made structure that's a road.
I may have lost the Q&A questions with my power outage.
I answered both of the questions via text that were in there, but I want to give the rest of the attendees the benefit of those. So if it's okay with you, Mary, I can just.
One of them says, does the Sackett decision impact other federal laws like Swamp Buster that regulates farming in wetlands?
Say that one more time. I'm sorry.
Does the Sackett decision impact other federal laws like Swamp Buster that regulates farming in wetlands?
Yeah, I don't know on that law in particular. That's one of the very few things that I don't do at MEA is agricultural law. That's my counterpart, Adam Voskul, over here. But what I will say is that the case very much focused on the definition of waters of the United States as that is defined only in the Clean Water Act and the ramifications of that under the Section 404 permitting program. Whether or not it impacts other laws likely would require those laws to somehow incorporate that same definition by reference. Otherwise, it certainly wouldn't have a direct, like, precedential impact on it, even though maybe a court could point to it as some evidence to the answer to that question. But that's about as much as I got on that one.
Beverly asked, there's an article in the Chicago Tribune recently about oil and steel companies near Joliet dumping toxic waste in the nearby canal, which carried this waste to Lake Michigan. This is still going on. And her question is, can the EPA sue these companies, or should the state of Illinois be able to do this?
Well, anytime we're talking about the dumping of a toxic substance, there is a whole regime of regulations that's not limited to the Clean Water Act itself, right? We have TSCA, the Toxic Substances Reporting Act. We have CERCLA. We have that's our Superfund law. We also have RCRA, the Resource Conservation and Recovery Act, which is supposed to regulate toxic chemicals from quote unquote cradle to grave. So I would hazard that under at least one of those laws, if not multiple laws, that the EPA would have jurisdiction to potentially bring in enforcement action. If authority under those laws has been delegated to the state of Illinois, the EPA still probably enjoys some residual enforcement authority, but Illinois would also have enforcement authority. And depending on which law actually gets triggered, like the Clean Water Act, there's actually citizen suit provisions to prevent, right, that you could bring over like an ongoing discharge, right, if either the EPA or the state didn't diligently prosecute a violation. So not only could the EPA or maybe the state, right, environmental agency there bring that action, but citizens short of those two may be able to as well. I'm not as familiar with that particular issue, but as described there, I would suspect there's some authority. I don't know whether they are, but I bet they can.
So Judy asked, is there any doing navigable waters so that all waters of the U.S. would have protection? Isn't that an old law from Harbors Act way back? I don't know Harbors Act.
Yeah, that's a reference to the Rivers and Harbors Act, which actually which will regulate at the federal level, typically anytime you're crossing, like building a bridge or other sort of structure that may obstruct navigation in a navigable water, right? But is it perhaps the discharge of, dirt or something like that that would fill that up? And that is a really old law. I want to say 1899 or something like that, but and it has been slightly updated, but that's a different law, right? And that was on the books when the Clean Water Act was first enacted in 1972, and when its predecessor before that was enacted in 1948. But even though they may use similar terms, right? Again, separate laws. And as I explained in my slideshow, the definition of navigable waters under the Clean Water Act is different than that kind of long-standing interpretation of navigable waters in case law, and I would hazard in the Rivers and Harbors Act. So not much overlap there. Right, but the only way I see of getting back to maybe a significant nexus test, or maybe this more science-based approach, right, whether there's an actual impact on these waters, one of two things. You'd have to have a newly constituted majority on the Supreme Court, right, to re-raise this issue in front of them and hope that they take the case and it's novel enough. But short of that, an act of Congress, they would have to amend the Clean Water Act. To expand that definition back and combat that judicial interpretation of the term.
Carolyn wants to know about wetlands when they've been interrupted, like walking trails or train tracks or dikes. What happens to that continuous surface water? Is this land no longer considered a wetland when those structures are built?
Well, it's super interesting because you would think that in order to construct a walking trail or train tracks, or even to build a certain type of dike, right, those all involve the discharge of fill material, right, likely to build those things up. And if we're talking about a wetland that was historically adjacent to that surface water, well, where's the permit for that, right, to even interrupt that in the first place, because they would be adjacent. But of course, that law was only on the books starting in 1972, and there's all sorts all over the country of existing situations where there's a road or a train track and things like that. And even if it's man-made, like the road at issue in the Sackett case, and it interrupts that continuous surface connection, it suggests that there would be no jurisdiction, at least under the Clean Water Act, for discharges to that water body if there is no continuous surface connection. And even if there's still a hydrologic connection underneath whatever that piece of infrastructure may be.
Well, I think we're running out of time here, but kind of maybe a bit of a philosophical question. Anonymous says, how can the law ignore the science of hydrology? I'm not quite sure what this person is referring to there, but apparently this.
Just take out the words "the" and "of" hydrology, right? How can law ignore science? Well, lawyers have been doing it for hundreds of years, and we're really good at it. I'm thinking of a case from the late 19th century, so late 1800s, where the Supreme Court held that a tomato is a vegetable, right? When we all know that it's a seed-bearing fruit, right? But it's traditionally or colloquially thought of as a vegetable, and that's what they meant, right? So that it's a legal fiction, right? And while we know now, right, what the scientific indicators are of a wetland, right, presence of water at or near the surface, hydrophytic conditions and plant life and all those things, right? When the Clean Water Act was passed, it used a legal term of art. And so that's where we have the disconnect, is when those legal terms of art don't map perfectly on top of the actual scientific situation on the ground, and that is not peculiar to hydrology, right? I mean, you got me started, but for fear of this going way over time, maybe we'll just answer. We'll leave the answer at that. That's what lawyers do.
I really appreciate this very much, Rob. I mean, this is a lot to absorb. My notes are going to be interesting if I can read my own scratches, but it's very helpful. A good look at where we're at now, but it seems to me like I would just ask you to maybe speculate on the future. It's all speculation, but clearly our current political environment may not be the best for some of these changes we'd like to see. But on the other hand, sometimes I'm surprised by politics. But what is your sort of best guess of where we're at now and where we might be in, say, 4 or 5 years?
Well, I think a lot of the states, right, that don't have like backup wetland regulatory programs, right, and that were really dependent on the federal government, many of those are likely to stay the same, right? And so even though maybe they have less wetlands than other states or not, right? Like where I'm from down in Arkansas, which has, originally they have so many wetlands, right? And around the rice fields and in the Mississippi and Arkansas River Delta that simply will no longer be covered here. And in that state, given the political environment, I don't see a path forward, right, to filling in the gap created by the Sackett decision. So in many places, that Sackett may be the standard for a long time to come. I think in certain states, still depending to a certain extent on the politics, may have an opportunity themselves to fill those gaps, right, and where they haven't been already, or start to realize there are more gaps than they knew about before, and take some action there. But as you say, given the kind of current national political climate, I don't see a large appetite like there was in the late 60s and early 70s when we had the movement to try to holistically address these issues. So I think the future depends on where you're at, I think, on like a parcel by parcel basis, and then what those add up to in the individual water bodies. But we can't forget, right, that the hydrological cycle, whether groundwater, like cloud, surface water, et cetera, right, it doesn't respect state borders, right?
Mm-hmm.
So a lack of regulation in Iowa could have a serious problem for on the other side of the Mississippi River in Illinois. The same with Wisconsin and Minnesota. And so it'll be interesting to see how some of those things play out. I hope that it's not going to take like the Cuyahoga River being on fire again, or another Love Canal to kind of snap the general public out of maybe some complacency there. But I don't know. I don't know, broadly speaking, if that's possible. What I do know is possible is that folks on the ground paying attention to what's going on in their communities and understanding how hydrology works together and why those things matter, and then bringing those issues on a repeated basis to decision makers and forcing them to address it, right? That access at power, that has been one of the most effective means, at least trying to get issues addressed on a local level. But even then, there are issues, right? State governments preempting local governments, right, from regulating in the shoreland or wetland zone and all of those things. So I think it's going to take a lot of education. And unfortunately, I think it's probably going to take some adverse impacts to wetlands that are vital for us to be able to say, see, this is why we needed that significant nexus test.
Mm-hmm.
But that means injury to the environment, and the loss of all the benefits that wetlands provide us that were overlooked for just so long, right?
Right.
And just led to large swaths of those ecosystems being destroyed, except for the last 50 years. So it's not a rosy outlook, I don't think, but I'm also cynical lawyer, so grain of salt.
Yeah. Well, again, thank you so much for this. And the recording will be available on our website later on. And Gretchen did a wonderful brief blog on this topic. So I think there's lots of ways that the membership can spread this word and share this message so that we all have a better understanding of it. So it's part of our league effort is advocacy, and the whole focus of the Upper Mississippi River Region League is to make people more broadly aware that, as you just said, Rob, water doesn't respect state boundaries. And so everything we do, and I just say the Upper Mississippi River region is certainly just a portion of the whole river watershed. So it's a very important topic. Thank you. And I'm so glad that we've got a connection to your organization on our website where people can send questions and get information, because we like having all of those great resources. So really appreciate it, Rob. Thank you for being with us today. Any last words, Gretchen?
Yeah, I'm trying to. Sorry. I want to remind people that we have the CO2 pipeline meeting coming up on December 4th.
Excellent. Another big issue that crosses state boundaries that we all should be concerned about. So if you haven't registered for that, be sure to pop on the website and send in your registration. And we've got some great people. We've got people from 3 different states, I think, lined up to talk about the pipeline. And certainly that right now there's a lot of action going on in Iowa for sure. A lot of delaying too, to some extent, but I'm very impressed with the number of organizations that have jumped on this issue. Thank you, Gretchen, for once again doing great yeoman's work on our webinars. And thank you all for attending.
Thank you.